Unflanked. Yeah. Okay.
He's going to be petitioner's side.
Wait,
you
hold on.
both take your spots.
Here? Oh, sorry, my bad.
Yeah, you get you're both going to be standing up and both sworn as witnesses. You raise your right hands.
Do you solemnly swear under penalty of perjury that the testimony you are about to give and the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you both of you. You're formally on motion. Request that the court make a finding that Jason Davis contempt of existing court orders. Not very much the case. I think I first reviewed it yesterday. Now have the following things in mind. It appears that on August 22nd, 2023, that a order of disclaimer after hearing was entered with Mr. Elijah Dominguez as the protected party and Mr. Jason Dominguez as the restrained party. The order on its face says that both parties were present in court at the time that it was issued. I believe that that is the order that we are.
It was a peaceful contact order.
I do see that it's a restraining order after hearing. It is not a no contact order. It is a peaceful contact order in paragraph 12 of order CD-130 is checked. All of the things that Jason Dominguez is going to do. So the parties agree that that is the operative order that we're talking about.
Yes, Your Honor.
Okay. You also agree with Mr. Jason?
Yes, sir.
Okay. Then, for our purposes today, I'm going to consider that order August 22nd, 2023, restraining order after hearing order of protection. That is in paragraph. This mark is quite a bit of one. Then, in Elijah Dominguez's motion, I'm looking at a number of documents. The order to show cause is affidavit for contempt. Appears to have been signed by Judge Kim, also signed by Elijah Dominguez on December 14th. That's what stays here. There is a document entitled Motion for Contempt. The typewritten document. It has 3 pages, and it was filed on November 28th, 2023, and it is signed on it is signed over the I mentioned that document because there's been a number of documents filed, but this particular one, motion for contempt, 6 alleged violations of the restraining order. Do you have that document? I have a motion for contempt.
Where it has the 16?
Yes.
Yeah, they're all false.
Well, I wasn't yet asking for any.
But yes, I read them.
Okay, because that, in my mind, that is what we're here for, hearing on, which are these alleged violations. So I have that one as well. And I have all the other things. There are various legal authorities, points and authorities that were Mr. Elijah Dominguez submitted. Some exhibits that I have been submitted, documentary exhibits, all of those things. Jason?
No.
Yes.
Just the 16.
Okay. Well,
The problem was, Your Honor, the reason why I filed for a motion for continuance that was denied was because I hadn't been able to serve the party completely. There was some issues with the deadline, and I asked for a reasonable extension to be able to serve these documents, and I was denied by the Honorable Judge.
let me take a look.
I think I have also a copy of it, Your Honor.
I think I've got it right here. So what I see is there's a proof of service filed December 27th, 2023. Says that Jason Dominguez was served with the order to show cause and affidavit for contempt, motion for contempt, memorandum of points and authorities, and it's signed by John Adam.
That's him. That has their names too.
I would object to that. There's no proof that that's me, Your Honor. That's a person that I asked to sign those records and affidavit for me. I actually paid them cash in hand, Your Honor. So I don't have like no receipt or anything that I can show you where I paid the cash.
May I inquire, all right.
If you want, Your Honor, like I said, if you can get a continuance, I'm more than gladly reserve the documents and paperwork, and I'll make sure they're served properly, Your Honor. And then I would ask that obviously the order stay in place, obviously, while I'm in the process of serving. That's what I would ask if the defendant doesn't want to waive service.
So, there doesn't seem to be any issue before the court tonight about changing the order. No one has brought a motion to terminate the order. So that's not what we're talking about.
No, I wasn't, I think there was a misconception of what I was saying. I was explaining that because I didn't serve, you're saying that the document wasn't served, but there's an affidavit there. You did not receive it there. I'm more than willing to make a good faith effort to serve him again. I'm just asking that the order continues in place till we didn't come back to this court to rehear this motion when the documents are served properly. Right.
You mentioned that you, from your perspective, you asked for continuance. After the December 14th order to show cause and affidavit was filed, after Judge Kim signed that on December 14th.
Yes.
Wait.
Oh, sorry.
Let's practice talking one at a time.
Yes, sir.
The next document that's filed is December 27th, proof of service signed by John Adam. There is then a request on December 27th by Elijah Dominguez for a remote appearance, and Judge Kim ruled on that request on, what date did I say?
It's December 27th, sir.
Judge Kim ruled on that on December 27th. Just checking. If I said July 27th, I meant December 27th.
No, you were correct, sir. You said it correct.
And then on January 2nd, a motion for reconsideration for remote access was filed, and a motion for electronic evidence and foundation authorities in support. Does that, may I inquire from Elijah Dominguez, does that have to do with the 2 USB drives that you submitted?
Yes, sir. Those are those. So I submitted those previous before Judge Kim, and the reason the way the order is how it is because the Honorable Judge Kim didn't have the IT guy available at the time to the way that the USB is. He was unable to view it, so we had to have the IT guy look at it because it didn't format to your computer. Now, the thing was, I explained to him, well, that should have been done before, and that evidence was submitted, but it was never viewed by the physical judge. So when he issued the order, he issued a protective order based on statements made by the parties, and some of the evidence was submitted, and not all the evidence was submitted and looked and reviewed at the time that the order was issued for a peaceful order. I wanted a full no contact order, but because I was afraid of losing my home and Judge Kim saying that I would lose my home if I was to get a full restraining order, I tried to explain to the judge that the victim would have to find some way to another way to live, and mention the the Women's Against Violence Act, which is, it doesn't just apply to women, it applies to everybody, and domestic violence of all calibers. And I asked him, well, is there a way that I could, have this, is there a way that we could get around this? And there was no negotiating with him. I was unable to come to, we eventually came to the terms of a peaceful contact order, but I did not feel like at that point in time that I was having a fair hearing due to the fact that evidence wasn't even submitted there. I submitted evidence ahead of time in August on the 22nd, and that evidence was never fully reviewed, and I never really had a full due process proceeding because the IT tech guy was not available.
If I understand what you just told me, the 2 USB drives do not relate to the 6 ground.
No, they do.
No, this is before the,
Okay, wait a minute.
for the first hearing.
I need to encourage, or not just encourage, I need to insist that both of you let me finish my ideas.
I apologize.
I appreciate that. So So these two USB drives, these relate to things that occurred before the restraining order was put into place, is that
Yeah.
right?
Yes.
Yes, but
So,
they would,
wait, and I'm gonna I can clarify this. I don't need to look at that, right? The only issues that are before the court today are your claims of contempt.
so Your Honor, can I elaborate? So some of those films occurred during the incident of domestic violence. Those documents were submitted but never reviewed by the court. Judge Kim, again, said my IT tech.
Please don't repeat yourself.
Okay.
I was
And the thing was, there is.
I need to stop you now.
Um,
I need to stop you.
okay, sir.
And here's why. I cannot do anything about things that happened before the restraining order was put in place. I can't, and I won't. I'm not going to consider evidence.
There was evidence on there that occurred during the domestic violence. It's not just past evidence. There's evidence that since the order was in place, there's evidence that has been submitted, not just from past domestic violence that shows a pattern of behavior. They show a consistent pattern of behavior that this man loses his temper during simple conversations, and it's to the point where it has disturbed my peace. I'm not eating properly or sleeping, and there is evidence that has been submitted both from past events and events that occurred after the order. Him yelling, telling me things like, it doesn't matter. I can do what I want, whatever I want.
I'm sorry.
This is.
Can you please clarify? You're saying now that there's evidence on the USB drives of things that occurred after the order was put in place, and that specifically relate to the 6 grounds of contempt that you've laid out.
Yes, sir.
Okay. Have you received a copy of
No.
these exhibits?
No, I also want to say, this is what Elijah does. He files paperwork on people. He's got his mother, trying to get her put out of her home, his brothers, his sisters, probation officer, the whole probation department. If you call and talk to his probation officer, his felony probation officer that he has now, she can clarify a little bit more.
Your Honor,
what's
I would
going on.
object.
This is
No,
what he
I'm
does.
sorry.
I don't know if
Wait a
that's
minute.
possible.
I
Wait
would
a minute.
object.
Right now, you guys need to stop talking. Now, Mr. Elijah Dominguez, I have let you go on at length. So right now, Jason Dominguez is speaking, and you will be silent. Do you understand?
Yeah, okay.
If you guys interrupt each other, this hearing will come to a very quick end.
Understood.
It is not fair to the court reporter, and I'm not going to allow it.
Understood, sir.
He didn't interrupt you, so now you're not going to interrupt him. All right, Jason Dominguez, go ahead.
So his PO, Miss Jessica Landeros, I spoke with her last week about what was coming up here. She advised me as well that he's filed all kinds of reports on them as well. And this is what Eli does when he's, not doing his medication or doing his therapy, which is court order that he's supposed to do. He hasn't been doing it since I took him in homeless on felony probation because I wanted him to get through this. We tried to help him. It's just been hard with Eli because he doesn't do what he's supposed to do. All I ask him to do is do his therapy, take your meds. We'll help you find your own place of it.
Objection, Your Honor.
But
Give me a second, Mr. Jason Dominguez.
Yes.
What is the objection?
Your Honor, I would object to confidentiality regarding my medical records. Those are private records, medical records, and there has been no record that has been submitted to this court of any mental health. The statements would be inadmissible, sir. And I'd ask that the court strike that from the motion, strike that from the record, the mental health statements, Your Honor, due to confidentiality and the lack of submission of mental health records.
I agree with you that there have been no mental health records presented to the court, but I disagree with you that the other party may not offer testimony about their personal observations or familiarity with you around these issues. So your objection is noted and overruled.
Okay.
Anything else?
No, that's not.
No, just that, and I've really tried to help Eli this last year, but Eli wants to do what Eli wants to do. Rules don't apply to him. He thinks he's his own lawyer. He has his own company business. I mean, he has, I hate to say he's my son and I love him, but he is delusional and I can't help him. I've tried to talk with PO, he won't listen to her as well. I mean, it's been really hard with Eli, and he's been calls my work and does false accusations against me, trying to get me fired. Thank God I know, the HR people, and I just explained to them I'm his special needs son. He's actually this is constant. Every day, I probably have 1,000 texts on my phone that he does to me all day when I'm at work. And I work 10-hour days. I'm gone all the time. I leave him at home. Hopefully, he would further himself, but he just wants to smoke weed and file paperwork all day long, every day. So of course I'm frustrated when I come home. But I've never threatened him. I've never physically touched him. Yes, I've yelled, Elijah, why are you, please, leave me alone. Leave me alone. That's just about it. He considers that contempt of court.
Let me clarify. It appears that Jason Dominguez has told the court that some of these materials that were submitted, but not the specific allegations. You have those 6 allegations.
One that I read about peanut shells in the sink. Yes, that one I remember.
Well, why don't we do this? Because I think that it makes some sense. If the parties will agree, I will just have a full copy made. Do you have the order to show cause and affidavit for contempt showing today's court hearing? Why don't I do this?
Yes, I do.
Okay, you have that. That's
Yes,
a 2-page document.
Yes.
Actually, it says 4, but it says 1 of 4.
Oh shit.
In any event, this is what I have in our electronic records. Then I have the motion for contempt. It's 3 pages, and it has those 5.
Yes.
Sorry, I apologize. 6 incidents. You have that.
Yes.
And the next thing is the memorandum of points and authorities in support of contempt. It's 4 pages.
Yeah.
You have that.
Yes.
Okay. And there's exhibits in support of domestic violence. It's 2 pages plus a number of photocopies. You have that.
Yeah.
Okay. So it doesn't sound like there's anything that's missing. You got all of that. I'm a bit confused because I was told 2 separate things. That is that these USB drives contain information from things that happened before
And after.
Okay. Well,
And things happened before. Let me just clarify for the record, Your Honor. They happened before. These were things that happened where he had made criminal threats before, was the reason why I brought forth the domestic violence, which is the pattern of behavior. Then there's stuff that is after that I have recorded that is also on that USB cord that can show that he not only did the judge make an error when issuing the order, but there was stuff that showed that domestic violence had occurred, whether it's physical or verbal. Coercive behavior in the state of California is considered domestic violence. So
well,
I also have a copy of those. I can play audio for the court as well if it will please the court.
there is a bunch of files on this one USB drive, and anything that relates to things that occurred before the restraining order was put in place, that's not relevant. So I'm not going to consider it anything that depicts words or images from before the restraining order. What I will consider is anything that relates to the specific 6 incidents that you have laid out of alleged contempt.
Yes, and there's incidents on there of those alleged 6 contempts. Yes.
So those are the things I'd like you to show, and if you're prepared to play it, I understand, Mr. Jason Dominguez, you haven't seen these things before. Would you agree to simply having Elijah play it here in court so that we can both see it?
The only thing though is what he recorded is after he pushes my buttons and been drilling me all day,
You'll have a
and
chance
then he'll
to
record
explain
me.
your side.
Telling him to leave me alone. Then he records me.
You'll have a chance to explain your side, but right now he's the one who's brought the motion.
Yeah.
I have to let him go first.
Sure.
So is that okay with you?
It's
That
fine.
we watch it here? Okay. Why don't you cue it up and we'll watch it?
Yes, you would like me to play it? I don't have a computer.
Oh, I'm sorry, it's on the phone.
It's on a phone. I play. It's audio. I was only able to get audio of it, not video.
Okay. So all of these files are audio.
Already,
is that right?
there are some of them are video, some of them are, but most of them are audio because it's me holding the phone, and I'm basically holding it like this so he doesn't. You know, I was afraid to basically get attacked for recording him.
I see. All right. So if you are able to, when you play these things, we're not going to have a transcript of that. The court reporter is not required to make a transcript of the audio recordings.
Understood.
So, but you need to only play things that relate to the 6 instances you've alleged.
Yes.
So if you're prepared to do that, you could probably just maybe put the phone close to the microphone.
Okay, I can do that.
You won't be able to hear it.
Just give me 1 second here.
Take